Kirk, and this is MMS 101 Video Report on the Cybercrime Prevention Act, or Republic Act 10175. What is the Cybercrime Prevention Act of 2012, or Republic Act 10175? It is an act defining cybercrime, providing for the prevention, investigation, suppression, and the imposition of penalties therefor and for other purposes. The vital role of information and communications industries for the nation's overall social and economic development, and the importance of development-inducing, secure, accessible environment for the people is recognized by the state. In the prevention, detection, prosecution of all forms of misuse, abuse, and illegal access through or of information and communication technology, a law is therefore necessary. In this video, we will discuss about the origin of the Act, provisions in the Act, agencies and implementation of the Act, jurisdiction and other information, issues and disputes about the Act, and references. Origin of the Act. The Act originated from two bills, House Bill number 5808 from the House of Representatives and Senate Bill 2796 from the Senate. In the House of Representatives, House Bill number 5808 was filed on February 9, 2012. It was introduced by Representative Susan Yap, whom was also its principal author. Co-authors include Representative Eric Singson, Representative Marcelino Teodoro, and several others. It was then passed to the Senate on May 23, 2012. Senate Bill number 2796 was filed on May 3, 2011. It was proposed by Senator Edgardo Angara. It was filed by Senator Juan Ponce Enrile, Senator Manuel Mercado Lapid, and several others. Senate Bill number 2796 was filed on May 3, 2011. It was proposed by Senator Edgardo Angara. It was filed by Senator Juan Ponce Enrile, Senator Manuel Mercado Lapid, and several others. The Conference Committee for the Consolidation of the Bills was formed on May 30, 2012 as requested by the House of Representatives. Conference Committee members from the House include Tinga, Yap, Singson, and others, while Conference Committee members from the Senate are Angara, Santiago, Ejercito Estrada, and others. The Conference Committee bill was passed in the House and in the Senate on June 4, 2012 and June 5, 2012, respectively. The Conference Committee bill was then sent to this guy. Yes, the guy on the glasses on the left, not me. Yes, the President was given the law on August 15, 2012, and it was signed and approved on September 12, 2012. Provisions in the Act. This Act shall be known as the Cybercrime Prevention Act of 2012. The following terms are defined in the Act and is necessary in understanding the provisions. For example, computer, service provider, without right, alteration, cyber, access, interception, traffic data, communication, system, database, program, and others. Offenses against the confidentiality, integrity, and availability of computer data and systems. Illegal access, access to the whole or any part of a computer system without right. Illegal interception, interception made by technical means without right of any non-public transmission of computer data to, from, or within a computer system, including data in electromagnetic emissions. Data interference, intentional or reckless alteration, damaging, deletion, or deterioration of a computer data, electronic document, or electronic data message without right, including the introduction or transmission of viruses. System interference, intentional alteration or reckless hindering or interference with the functioning of a computer or network by inputting, transmitting, damaging, deleting, deteriorating, altering, or suppressing computer data or program, electronic document, or data message without right or authority, including the introduction or transmission of viruses. Misuse of devices, the use, production, sale, procurement, or otherwise making obtainable without right of a device designed primarily for committing offenses, or computer password, or any form of access code by which a computer system is capable of being accessed with intent that it be used for the purpose of committing any of the offenses under this act. The possession of the said device or item with intent to use device for the purpose of committing any of the offenses under this act. Cyber squatting, the acquisition of a domain name over the internet in bad faith to profit, mislead, destroy reputation, and deprive others from registering the same if such a domain name is identical to an existing trademark registered at the time, identical name of a person, and acquired without right or with intellectual property interests in it. Offenses that are computer-related. Computer-related forgery. Input, alteration, or deletion of any computer data without right, resulting in inauthentic data with the intent that it be considered for legal purposes as if it were authentic, and the act of knowingly using such computer data for the purpose of perpetuating a fraudulent or dishonest design. Computer-related fraud. Unauthorized input, alteration, or deletion of computer data or program, or interference in the functioning of a computer system causing damage thereby with fraudulent intent. Computer-related identity theft. Intentional acquisition, use, misuse, transfer, possession, alteration, or deletion of identifying information belonging to another, whether natural or juridical, person. Offenses that are content-related. Cybersex. Willful engagement, maintenance, control, or operation of any lascivious exhibition of sexual organs or sexual activity with the aid of a computer system. It can be directly or indirectly, for favor or consideration. Child pornography. Unlawful or prohibited acts defined and punishable by Republic Act No. 9775 or the Anti-Child Pornography Act of 2009, committed through a computer system. Unsolicited commercial communications. Transmission of commercial electronic communication with the use of computer system which seek to advertise, sell, or offer for sale products and services that are prohibited unless there is a prior affirmative consent from the recipient or the primary intent of the communication is for service and or administrative announcements, or the commercial electronic communication contains a simple, valid way for the recipients to reject receiving other messages. Libel. unlawful or prohibited acts of libel as defined in Article 355 of the Revised Penal Code, as amended, committed through a computer system or any other similar means which may be devised in the future. Other offenses in relation to the aforementioned acts are aiding or abetting in the commission of cybercrime, which means any person who willfully abets or aids in the commission of any of the offenses enumerated in the act shall be held liable. Attempt in the commission of cybercrime. Any person who willfully attempts to commit any of the offenses enumerated in this act shall be held liable. Other offenses in relation to the aforementioned acts are cybercrime and revised penal code. Crimes defined and penalized by the revised penal code as amended, and special laws if committed by, through, and with the use of information and communication technologies shall be covered by the relevant provisions of this act, provided that the penalty to be imposed shall be 1 degree higher than that provided for by the revised penal code, as amended, and special laws as the case may be. Liability under other laws. A prosecution under this act shall be without prejudice to any liability for violation of any provision of the revised penal code, as amended, or special laws. Penalties against offenses aforementioned. Computer data and system offenses and computer-related offenses. Penalties are imprisonment of prison mayor, fine of at least 200,000 pesos, misuse of devices, imprisonment of prison mayor of fine of not more than 500,000 pesos. Computer data and system offenses committed against critical infrastructure, penalty of reclusion temporal or fine of at least 500,000 pesos. Cybersex, imprisonment of prison mayor or fine of at least 200,000 but not exceeding 1,000,000. Penalties against offenses aforementioned. Child pornography committed through a computer system, punished with the penalties as enumerated in Republic Act No. 9775, and the penalty to be imposed shall be 1 degree higher than that provided for in the Republic Act 9775. Unsolicited commercial communications. Penalties are imprisonment of arresto mayor or fine of at least 50,000 pesos but not exceeding 250,000 pesos. Aiding or abetting in the commission of cybercrimes. Punishment is imprisonment of 1 degree lower than that of the prescribed penalty for the offense, or fine of at least 100,000 pesos but not exceeding 500,000 pesos or both. Attempt in the commission of cybercrime. Same as before, punished with imprisonment 1 degree lower than that of the prescribed penalty for the offense, fine of at least 100,000 but not exceed. Penalties against corporate liability. When any of the punishable acts defined are knowingly committed on behalf of or for the benefit of a juridical person by a natural person acting either individually or as part of an organ of the juridical person shall be held liable for a fine equivalent to at least double the fines imposable in the section of liability under other laws, up to a maximum of 10 million pesos. Commission of any of the punishable acts defined was made possible due to the lack of supervision or control by a natural person referred to and described in the preceding punishment for the benefit of that juridical person by a natural person acting under its authority, the juridical person shall be held liable for a fine equivalent to or at least double the fines imposable in the liability under other laws section, up to a maximum of 5 million pesos punishment. Responsible for the efficient and effective law enforcement of the provisions of this Act are the following government agencies. The NBI and the PNP shall organize a cybercrime unit or center manned by special investigators to exclusively handle cases involving violations of this Act. The Department of Justice shall create the Office of Cybercrime as the central authority in all matters related to international mutual assistance and extradition, while the law also provides the creation of the Cybercrime Investigation and Coordinating Center, or CICC, under the Office of the President. This center shall facilitate policy coordination among concerned agencies, formulation of national cybersecurity plan, and enforcement of the law against cybercrime. Law enforcement authorities have duties and authorities given by the law. Duties of law enforcement authorities. They report annually to the DOJ for monitoring and for reporting pre-operation, post-operation, and investigation results. Preservation of computer data. Integrity of traffic data and subscribers' information provided by a service provider shall be preserved for a period of 6 months from the date of the transaction or date of receipt of the order of preservation. It can be extended to 6 months by law enforcers in just one more time. Search and seizure and examination of computer data. Authorized to secure data storage medium, retain a copy, maintain the integrity of the data, analyze the data, and render inaccessible any data. Disclosure of computer data requires warrant from the court. Disclosure of traffic data and subscribers' information or relevant data by anyone within 72 hours from receipt of the order. Custody of computer data. All analyzed and examined data, including copies of the data and the examination details, should be in the custody of the court within 48 hours of the expiration of the warrant and would be disclosed only by rule of the court in the presence of the person in or related to the data. Real-time collection of traffic data. Authorized to collect traffic data in real time. Content data needs warrants, which is granted if with due cause. Destruction of computer data. Upon expiration of the periods in orders and laws, service providers and law enforcement authorities shall destroy the computer data subject of preservation and examination. Other rules and regulation. Exclusionary rule. Any evidence procured without a valid warrant or beyond the authority of the same shall be inadmissible for any proceeding before any court or tribunal. Restricting or blocking access to computer. When a computer data is prima facie found to be in violation of the provisions of this Act, the DOJ shall issue an order to restrict or block access to such computer data, or in other words, they put power on the DOJ. Non-compliance. Failure to comply with the provisions on this law, hereof, specifically the orders from law enforcement authorities, shall be punished as a violation of Presidential Decree number 1829 with imprisonment of prisión correccional in its maximum period, or a fine of 100,000 pesos or both, for each and every non-compliance with an order issued by the law enforcement authorities. Jurisdiction and other information. Jurisdiction of cases. The regional trial court shall have jurisdiction over any violation of the provisions of this Act. Any violation committed by a Filipino national regardless of the place of the commission. Any of the elements was committed within the Philippines. For example, the use of any computer system wholly or partly situated in the country, or when by such commission any damage is caused to a natural or juridical person who, at the time of the offense was committed, was in the Philippines. There shall be designated special cybercrime courts manned by specially trained judges to handle cybercrime cases. General principles relating to international cooperation. All relevant international instruments on international cooperation in criminal matters, arrangement agreed on the basis of uniform or reciprocal legislation, and domestic laws, to the widest extent possible for the purposes of investigations or proceedings concerning criminal offenses related to computer systems and data, or for the collection of evidence in electronic form of a criminal offense shall be given full force and effect. Issues and disputes about the Act. When this law was passed, or before it was, during when it was being made, or after it was passed, there were issues and disputes relating about the Act or how it will affect society. One of the big things is libel, online libel to be precise. Online libel is described as any acts of libel as defined in the revised penal code that is done through a computer system. For example, if I post a libelous post in Facebook, Twitter, or any social media, that is considered a libelous act according to the law. Now, in the law, there's no clarification if anyone who likes my post, my libelous so-called post, or shares that post or retweets that post, would that person be considered as a violator too? That is the questions asked by people, asked by lawyers or bloggers, journalists. And yet, even if the commenter or the one who shares or the one who likes is not considered a violator, the author of the post himself or herself is considered a violator, and that is one of the controversies of this act. One of the main things lawyers want to point out in these controversies, in these issues, is that when it was passed, there was no clarified who or how. For example, in posting a libelous act, online, one would say that that person is a violator according to the law, according to the Republic Act 10175. But then, that would mean curtailing the freedom of expression. If one is liable inside this law, one can be sued. One can be brought to court and sued because of this law. So, for example, any whistleblowers, anyone who wanted to reveal secrets or truth or knowledge of whatever they know, that is, they need anonymity, they can use the internet, or any journalist or news group, or anyone, bloggers wanted to express freely what they think, can be afraid to fully express what they want to, due to the fact that they can be sued. They have a threat in them. They have a threat of being sued through this law. Even though the DOJ struck down that part as unconstitutional, the part that the online libel for the commenters, for the one who shares, for the one who likes, is unconstitutional, meaning anyone who likes a post, libelous post, shares it, or retweets it, or receives it, is not liable under the law and is therefore not capable of being sued. But in respect to the author of the post, the original author of the post, he is liable under this law and can be sued through this law. Another main point that people came to talk about was the revised penal code punishment. When the law was made, there was no libel, or there was no revised penal code punishment. It was inserted after the committee. One of the main things is that the revised penal code has a whole set of list of violations. Now what they did was they put all of that and put it inside this law, and made every violation they had there that is committed through a computer system be made 1 degree higher in punishment. It will mean any act that I do that is considered criminal or considered prohibited in the law, according to the revised penal code, if I do it through the computer system, then it is punishable, and I am punishable by the law 1 degree higher than the punishment provided in the revised penal code. And that would mean many years in jail. The level will be 1 degree higher. That's the question some of the lawyers are asking. Is offense from the revised penal code made through a computer system, by making it through, or doing the offense through a computer system, would that make it heavier so that we can put a higher penalty? Another issue regarding this law is the real-time traffic data. The real-time traffic data allows or authorizes law enforcement authorities to without warrant ask service providers or any who provides information or hold information about the communications, the traffic data, like ISP address, where did it come from, when did it go, to whom, but the content of the data is not authorized to be seen or to be disclosed. But the fact that the law authorizes law enforcement agencies to get traffic data without a warrant makes it possible for them to espionage. Now it is not to that point of espionage, but it is one of the fears of lawyers, students, bloggers, lawmakers. Another issue regarding this law is the part where the DOJ is given the power to take down or render inaccessible the websites that are deemed prima facie as violations of the law. For example, if my website is let's say for example pornographic websites, without warrant or without any trial, the DOJ can suddenly authorize shut down the website without any trial. Now, in terms of pornographic websites, this is a good idea, but what people are saying is, if I have a website, if I have a blog, if I have a news, if I have a personal website, if there's something libelous, if there's something that is prima facie, meaning in the face, it looks in the front, it looks like a violation without doing anything else. The DOJ has the power to just shut down the website. No trial, no other processes. Now, the power may be that power, authorization would be good in terms of pornographic websites or any website that is really unethical or wrong in terms of our societies. But in terms of like libel, the government can say shut it down because it's libelous. The DOJ, specifically the Secretary, the Department of Justice, referring back to online libel, in the 2013 to 2015 report of the cybercrime law, as said in the act, they are required to report to the DOJ Office of the Cybercrime for investigations, for details about their annual proceedings. In their proceedings, I found out that online libel is second to the highest of the crimes committed during 2013 to 2014. It is 16%. Well, the first one is internet fraud or scam, the highest rate. The second place is the 16% online libel. The cases, dealt by the PNP or NBI or any involved agencies. The following was struck down by the DOJ as being unconstitutional. Section 4C(3) or unsolicited commercial communications. Section 7, liability under other laws. Section 12, real-time collection of traffic data. And Section 19, restricting or blocking access to computer data.